A judge by his status and position would more likely uphold the integrity of the judicial system. Because the judge, and since the judge decided the legal issues, whilst the jury decided the facts, adopting the jury system would further increase the duration of criminal justice cases, particularly those concerning corruption and bribery. Those were my reasons. But since then, we have seen, and in my present privileged position, I've been able to see that corruption amongst the judiciary is so rampant that all the assumptions I made earlier no longer apply. Same thing applies to corruption in the legislature. That's why you see me having a running battle with them all the time. The corruption in the legislature is simply terrible. Unfortunately, in recent years, a lot of evidence has established that some judges cannot be relied upon to uphold the integrity of the judicial system. They appear prone either to bribery and corruption or bias as a result of their relationship with the defendants before the court. An example of this is the increasing demonstration of esprit de corps between trial judges and judges who are defendants before their courts. It would appear that technical knowledge in the law, legal knowledge, technical legal knowledge, is being used as a barrier to the attainment of justice, thereby making the knowledge of the law a negative factor in the determination of guilt or innocence in criminal cases, particularly in corruption cases. This esprit de corps can be cited in many cases where judges seem absolutely incapable of convicting their colleagues who are charged with bribery and corruption. I will give one example, and that's really the main point I'm making. A disturbing example of this phenomenon occurred in a recent case, which shall remain nameless and without title. In that case, a judicial officer was charged with corruption for the following reasons. 1, 30 million naira had been paid into the account of the wife of the accused judge in 3 installments by a lawyer who was appearing before him. 2, the same lawyer bought a car worth 8,500,000 for the son of the same judge who was under trial. 3, about $525,000 was found in the defendant's bank account. 4, in a raid of the judge's home by security officials, the following amounts of money was found: 6 million naira cash, $121,279 US cash, 4,400 euros cash, 80,000 pounds sterling cash. 5, it was also found that the same defendant transferred 85 million naira and separately 90 million naira to an investment company for his investment. There were various other amounts and accusations or allegations involved in this case, but I don't think that needs to detain us. These examples are given enough. For example, the judge was accused of demanding and receiving 25 million naira from another person who had a case before his court. The trial court dismissed all the charges against the judge. The trial judge who tried this judge dismissed all the charges against him for the following reasons. 1, regarding the 30 million paid into the wife's account, the court held that since the wife did not transfer the money from her own account to the judge's account, there was no evidence of conspiracy to commit any offense or of corruption against the judge. On the contrary, said the judge, the trial judge, the finding of the trial court was that the 30 million naira was a gift from a well-wisher who intended to support the judge on trial towards the expenses of his daughter's wedding. 30 million gift to somebody whose daughter is about to get married. How much did that person spend himself? Maybe 30 billion. 2, the same reason was given by the same judge with regard to the car bought for the son. Since the son was the beneficiary of the car gift, according to the trial judge, the accused judge could not be accused of committing any offense because the beneficiary of the gift was his son. With regard to the charge of corruption involving $525,000, the trial court's finding was that the money arose out of the judge's share in the sale of some family estates. Next, with regard to the two sums of 85 million and 90 million transferred to an investment company, the court found that there was no unlawful act on the part of the defendant regarding the charge of unlawfully acquiring these sums of money. The court was of the view that the accused or defendant had earned all these monies from his salaries, estacos, allowances in dollar and other foreign currencies as a judge and a legal practitioner who practiced for 20 years. For over 20 years. Who practiced for over 20 years, during which he made investments before becoming a judge. According to the trial judge, the defendant judge had inherited real estates from his grandfather, who was a prominent public office holder in the past. Additionally, the defendant judge also inherited considerable assets from his own father, who was also a high public officer in the past. It could therefore not be said that a man who had earned all the said foreign currencies from estacos and allowances amounting to 525,000, and if it's estacos, you are supposed to have traveled and spent part of it, if not all of it. The said foreign currencies from estacos and allowances and so on, after elevation to the bench, who had a family background of the type already stated, he said it could not be said that he did not possess the capacity or even goodwill to muster the 90 million and also the 85 million to invest in property. In conclusion, the court stated as follows, and I quote the judge: it must be said aloud and clear, that while the nature of the judge's duties make him live solitary and humble life, that does not mean that every judge is a church mouse and cannot be blessed with a rich, affluent, and prodigious background from which he can live a decent life or make investments. Apparently, you need all these amounts of money to live a decent life. The judge continued, therefore, all these monies were not obtained by unlawful activity. Specifically, the judge's salaries, which were just over 6 million a year, just over 6 million a year compared to the amounts we're talking about, could not be regarded as the sole source of the judge's earnings. For the defendant was in receipt of estacos and allowances from externally funded conferences, workshops, seminars, and others, plus inheritance from his grandfather and father. That explains why he had all this money. In addition, other income which accrued to the judge came from investments in blue chips, exactly his words, didn't say companies, blue chips, his properties, estates of mother, father, and grandfather were resources he controlled in addition to his salary. You can see the judge actually explaining on behalf of the accused. It is important to stress that these extraordinary sources of vast wealth were never proven to exist because the trial judge held that the defendant had no case to answer. Therefore, all these claims and assertions of great wealth of Saudi Arabian proportions were never proved in court. The defendants did not have to defend themselves or be subjected to cross-examination, during which they would have been compelled to prove ownership of all the assets found on them. The defendant judge or accused judge would have had to establish his parents' ownership of specifically identified properties. When were they sold? To whom were they sold? How much was realized from the sales? All these are duties would have been compelled, information would have been compelled to give to the court, but it was saved that problem. The first defendant, that's the judge, would have been compelled to list all the conferences he attended abroad and how much he was paid on each trip to enable him accumulate $525,000. He would have had to establish that what investments he made in blue chip companies to earn 170 million naira. He would have had to establish his relationship with the well-wisher who paid 30 million into his wife's account. And that 30 million, by the way, paid into the wife's account, was paid by a judge, a lawyer appearing before him, who said he got the money from the well-wisher. He would have had to satisfy the court about the type of wedding his daughter had in order to attract 30 million gift from a well-wisher. But he was saved all that by the trial judge, who held that the defendant had no case to answer and therefore did not have to prove the claims of outstanding wealth in his defense. So the defendant simply got away with clearly outlandish claims. There are a number of similar cases going on now involving lawyers depositing huge sums of money in the accounts of judges before whom they are appearing. The usual explanations of these judges explanations for these huge deposits by these judges are that their daughters were getting married. Their daughters were getting married. They had lost their relations like father, mother, auntie. Their uncle was being made a chief and things like that. Now, after my recovery from the shock of the above decision, because this one decision is the cause of my change of position. After my recovery from the shock of this above decision, it dawned on me that legal knowledge could make a judge prone to legal technicalities, creating a barrier between technical law and justice. It would also empower any judge who is unfavorably disposed to the trial of a defendant to scuttle the case of the prosecution by professing to believe wild stories that cannot even be told to Marines. So this is why I became convinced that criminal justice, particularly in corruption cases, cannot be successfully and fairly disposed of in Nigeria unless ordinary laymen and women who still have a sense of outrage, decency, of wrongdoing, and basic common sense are legally empaneled to decide the guilt or innocence of persons charged with crime, particularly the crimes of bribery and corruption.